We will be beginning shortly. In 5 minutes, we will be beginning.
Hello.
We will be beginning shortly. Our expert is yet to join. Mastering the law begins with mastering the details. Every case file you read and every internship you experience shapes the lawyer you become. Good evening, everyone, respected dignitaries, esteemed speaker, and all the bright minds joining us today. I, Manjari Saxena, extend a very warm welcome to each one of you. It is my absolute pleasure to welcome you all to the AFIAI Intensive Certificate Program on Legal Research and Career Pathways. Before we begin, allow me to briefly introduce the institution behind this initiative. The Asian Forum for International Academic Interaction, AFIAI, established under the aegis of the Nyayat Foundation Trust, is a dynamic platform dedicated to fostering academic collaboration, research excellence, and practical engagement in law and allied disciplines. With a strong focus on the alternative dispute resolution, international law, and emerging legal frameworks, AFIAI aims to bridge the gap between theory and practice by bringing together academics, practitioners, students, and industry experts across borders. Through its conferences, workshops, training programs, and collaborative research initiatives, AFIAI continuously promotes knowledge exchange, skill development, and innovation in legal scholarship. Guided by its vision, empowering knowledge and advancing resolution, AFIAI is steadily emerging as a hub for academic interaction and professional growth in the global legal landscape. This intensive certificate program spans over 4 weeks from 27th of March to 19th April, bringing together a series of insightful and engaging sessions to deepen your understanding of legal research and career pathways. Throughout this journey, participants will have the opportunity to learn from distinguished academicians and industry experts, making it truly enriching and practical learning experience. Today's topic is both relevant and essential for every law student. Reading case files effectively and making the most of the internships. It is now my honor to introduce our distinguished speaker, Advocate Aman Usmani. A seasoned legal counsel and advocate with over a decade of experience, he brings with him extensive expertise in corporate advisory, litigation, and regulatory compliance. His professional journey spans reputed law firms and corporate environments where he has handled complex matters relating to corporate and commercial law, contract drafting, and negotiation, dispute resolution, and merger acquisitions due diligence. He currently serves as legal consultant at Technosage Consulting, where he advises on cross functional compliance and legal strategies. As an alumnus of Aligarh Muslim University, Advocate Usmani has further strengthened his expertise with international certifications in anti money laundering, privacy law, and data protection and contract management. Sir, we are truly privileged to have you with us today. To all the past participants, this is your opportunity to learn, engage, and grow, so make the most out of it. Without any further delay, I invite Advocate Aman Usmani to take the session forward. Over to you, sir.
Thank you for the warm introduction. Am I audible?
Yes, sir. Yes, sir.
Good evening, everyone. I am Aman Usmani, and I am delighted to be the part of this session under AFAI Intensive Certificate Program on Legal Research and Career Pathways. My work primarily involves litigation, corporate advisory, and regulatory compliance. And through my journey, I have come to realize that one of the most crucial yet underdeveloped skills among law students is the ability to effectively read and understand case files. So this is very important aspect of the litigation part, and many of you who joins some lawyer or an advocate in the court for internship program, and during that 1 month or 2 month and whatever duration you join them and be there as a part of their team, and to maximize your expertise there and to learn more and more about litigation, so that it can become your part of understanding how the court works and what are the mechanism through which the suit or the plaint or some of the cases that goes on in the court. So today I will be sharing practical insight on how to approach case files systematically and how you can truly make the most out of your internship experience in the Indian legal system. So first of all, if you're going through the slides, the slide is visible to you.
No,
Hello,
sir.
am I audible?
Yes, sir, you're audible. The slides are not visible. It will be visible in a
The
minute.
moderator, I request the moderator to please display the slide.
Yes, yes, sir.
Okay, so, is it's visible now, right?
Yes, sir.
Kindly confirm.
It is visible.
Okay. So first of all, when you are reading any case file in the office or anywhere, okay, so first of all, what are you going to evaluate first, as in the elements and the structure of a case file? So it can be a writ, it can be a petition, it can be a suit file, a complaint case, anything whatsoever. So I'm not going into depth of the category of the case files, because I guess it's a vast topic and you should uh, be with me for the later part of the series, so that you can go into depth of these things more properly. Okay. So first, on please bring the page number 2. So first, we go through index and dates. So when you open a case file, so first and the foremost thing that you have to draft, as an advocate or as a lawyer, when you are drafting, and the first thing you see when you're observing as a student or as an intern, the first thing you see is the index, where everything that is in the case file is arranged, like there is a memo of the petition, or there is an application, or please bring the page back, or the application, or the written statement, or the prayer, or any affidavit, or the IDs of the deponent, and every the all and the every element of the case is there in the index. And the second part of that is the brief part, is the dates and particulars of event has to be arranged after the index. So in that manner, you get to know what's in the case first. Second is the dates and the particulars of the events of the matter is arranged next to the index, and there you get to know very briefly what's the matter about. Now the second part is the plaint and the petition. These are the elements. Okay, I'm not going into very much into depth, because it needs more pondering and more explanation that has to be structured in a different session. So we will be sharing you the links for the further sessions, going to depth of these elements. So the second is plaint and petition. So the plaint and petition is what you are pleading in front of the court. So what you will plead in the court has to be written into your petitions. Either it is civil or it is criminal, like in complaint cases, you write everything what you are citing to the court, what you are demanding from the court, what is your grievance, what is your grievance, what is the issue, what is the cause of action. Everything has to be drafted in a particular plaint and petition. So it can be civil, or it can be criminal, or it can be in any category of legal domain. Okay. So the third part is written statement. Now what we understand by the written statement is, the written statement is basically for the respondent or the responding party in a suit or in a case. So one is the petitioner and the other is respondent or the opposite party. When a petitioner files a plaint or petition in a court, the court orders the respondent party or the opposite party to bring in their reply against that plaint or petition. So this is the mechanism. First a petitioner has to file a petition, move his petition against for his grievance. Then a notice has to be issued from the court to the respondent parties or the opposite parties, and then the opposite parties will ultimately file their written statement or reply. This is very basic elements that are relevant to this civil court or trial court, and to the some extent it will evolve into major portions of the element that is are used in high court and supreme court. But right now these are basic and has to be only uh, has only relevant in trial court or civil court. So and the next, the fourth is applications. So when a plaint is filed in a court, so it has to be, or it generally is accompanied with applications. Now what applications, under what section it is filed, you have to see what is the application for. Like if there is a civil suit, if there is a civil suit has to be filed in a civil court, so it will be accompanied with an application for interim stay or interim injunction for for any other relief sought by the petitioner through the court. So those has to be demanded or has to be moved by an application within the plaint. Now there would be a confusion within you people that when I am filing a petition, when I am filing a plaint in a court, why I have to move a separate applications for certain things that I want. Now the purpose of the applications are that they has to be accompanied according to the CPC when talking in the civil sense, and has to be moved as per the CRPC when talking about it criminal litigation sense, like in trial. What we use in trial, the CRPC and CPC, these are the procedure. So the applications are already embedded in these procedures, so they are the part of those procedures. So each and every application has to be moved within those procedures. So that's why CRPC and CPC, when you are doing law in 5 years or 3 years course, these are the important subjects and has to be read very carefully and by heart, because everything everything has to be evaluated according to these two procedures with two domain, as in civil and criminal practice areas. Now the fifth is evidence. So the part of evidence is what you attach with the plaint and petition. Now the attachment part is when you put an annexure, like I have the screenshot of a person against whom I am moving an application, or I am moving a certain document like a registry or like deed or or like this certified copy of any other uh, government this department, that has to be part of the plaint. So suppose a person who wants to move a suit for uh, temporary injunction. Now, what evidence he has to move before the court? He has to move the court, like he has to attach his registry or will deed, okay, citing his possession of the property. He has to prove his possession of the property. He is living over there, and what by what authority he is living over there, and he's in possession of the property. He has to give through his evidence. So that part is evidence. You have to remember these parts of a file structure and have to read accordingly. And last part is the orders. If there are any orders, any for that matter, any orders that has been passed previously before starting litigation, like there has been orders passed by certain authority, like any development authority, like any uh, these orders has to be passed by uh, generally by the government authorities. So can be nagar nigam, can be development authority, like can be electricity authority, or any authority you can think of. It can be passed by them, and these orders are also part of the evidence only, has been separated as the order. Okay, so Nick, kindly move the next page. So now for plain petition analysis, we we go through the file, and now we are going to understand the aspect of the case, or a plaint or a petition that has been already moved, or you are in a drafting stage. So what is the first thing that you go through to really understand what is the petition about, or what is the crux, or what is the soul of that petition? So first you go to the jurisdiction part. When anybody, any advocate or a lawyer who is drafting a petition, first he has to cite, as in into the petition. One is drafting into the petition, he has to cite his jurisdiction, justifying his jurisdiction of the court he is moving the petition in a particular court. Like if I am living in Jaipur, or I am living in Bangalore or Mumbai or Delhi. If I am living in Mumbai, I have to move a particular cause of action that has arose. I have to move a particular application plaint, okay, a writ petition in the jurisdiction of that area. I can only move to a civil court in a particular district. I can move a particular writ petition in that state, in high court, in this high court of that state. Like in that example, if I'm living in Mumbai, I have to move a writ petition in Mumbai High Court. But there are some cases where by statute there is a provision related to jurisdiction. But if that statute is not clear, then the local jurisdiction will fall for you when filing a petition. Okay, the first thing, very important part of that petition is jurisdiction, and that you have to include in your drafting. So the first paragraph in any petition whatsoever, the first paragraph clarifying is jurisdiction, under what jurisdiction, or the justification regarding the jurisdiction has to be cited. The second part is cause of action. Now the cause of action is what has caused you to file a plaint and a petition in a particular court. What has happened to your, what is your grievances, so you are filing that particular petition. Like I am, my house has been robbed, so I will go to a particular to my local jurisdiction, police thana, or a police station in my local jurisdiction, and get an FIR filed or lodged. And after the filing of FIR, the matter will, or the matter will go into a complaint case, into this particular jurisdiction with this cause of action that my house has been robbed on this and this date, and certain articles are missing, and has been damaged. So this is your cause of action. I'm citing just an example for your understanding. And the third part is facts. So the facts are has to be cited more in brief, and it has to be cited fully, without any hesitation. So everything and whatsoever related to the cause of action has to be put in your facts. Facts of the matter, facts of the plaint or the petition or writ petition, whatever applicable. The final is relief sought of the prayer. So why what do you understand by the relief sought of the prayer part is very important, because whatever you ask to the court as in demand or request, not as in demand, it would be derogatory, but I will say relief sought as in what are you requesting to the court. Okay, what you are requesting to the court, that it may be kindly, the certain prayer may be kindly given in my favor. So for example, uh, if the robbery has been done, I have filed an FIR and I have filed the complaint case later on. So my relief would be that it is requested by this honorable court that the expeditious and proper action may be initiated against such and such person who robbed my home. Okay, it's just a example prayer. It can be anything according to the cause of action. Kindly move to the next page. So written statement. This is the part that is for the respondent or the opposite party. Okay. So when certain notices are issued by the court to the responding or the opposite parties, so they need to admit certain facts of the petition, or they can deny according to their will wish and will wish and their strategy. So whatever I have to admit according to the in the counter of the plaint or writ petition or anything, I have to admit certain points that are very general in nature, and what I have to deny is the major part that has to be denied, so that uh, my grievance is also not uh, that unheard. Okay, so that could not go otherwise. So it has to be strategized. So what has to be denied or what has to be admitted while I am drafting my written statement, or what I am filing my written statement as a reply to the petition. Now second is preliminary objections. These are the objections that you have to cite in while drafting or the analysis while you're reading a case file. These are the objection primarily done by the opposite parties that they are not at all familiar with. They are objecting straight away. And the counter facts are those facts that are replied in the original facts. Like when I'm filing a plaint for the incident of robbery or in my home, so the opposite party, whatever it may come, and as an accused person, he may come and say that I was not in the town, I was elsewhere, and these are my alibi, and he has to counter fact this petition and through his written statement. The written statement will originally be filed by opposite party or the responding side always in a trial or a civil suit proceeding, either way. So move to the next page, please. So the evidence stage is basically when the suit or the trial has moved on. Okay, so the court calls upon the evidence. So, and everything that I'm this explaining, every thing I'm explaining is part of a file. So, so whatever is in the file is whatever is going in the court also. So it's counterwise, parallel to each other. So the evidence stage is the documentations that has to be brought upon the on record of the court, so that it can be evaluated as an evidence in support or to counter counter support to the accused or the petitioner. It has to be moved at evidence stage, and this is also in the suit or in the case file. So the second is written witness statements. The witnesses are called upon to support the original contentions of a petitioner. So if a person claiming that my house was robbed, so the neighbors of the person, the petitioner, will be called upon, or it has to be made of witnesses, so that their statement can be recorded in the court. So those are statements by the witnesses uh, involving the cause of action or the incident. So this is also a very important part of the uh, proceedings. So the third is cross examination points. So whenever the proceedings are going on in the court, in the file, the cross examination of the accused or the complainant or the witnesses are very important, and their cross is done by the other party. Like, if the complaint has been moved by the complainant will be cross examined by the counsel of opposite party or the accused party, and the accused shall be cross examined by the complainant counsel. So these are cross examined to to support their contention in the court, to prove their point, so that their case can be uh, their case can be balanced in their favor. Kindly move to the next page. So these are the case law related to part of pleading, and I want you to please note down the case law as it is with the citation, proper citation, and please go through each of the case laws and read it, because these are the landmark cases, and it will help you into the more understanding of these aspects of pleading. So the pleading part is what you are pleading in the court. These are the case laws related to that. The Trojan and Company versus Nagappa Chettiar, AIR 1953, SC 235. Please note it as it is. This is very important landmark case, and the basic part and the brief the brief part is: no amount of evidence can be looked into upon a plea which was never put forward. So whenever we are drafting a plaint or moving a plaint to a court, there is a principle supported by the CPC and the CRPC. Once again, coming to the two important procedures. So whenever you put forward a plaint, you when you draft a plaint, if you keep all the pleas as in statement of your contention of your facts, so you have to put it all. I said it before also, you have to put all in your petition, so that nothing gets left out. And when you leave out certain facts or certain plea into your petition and writ petition, so and when you argue upon the left out plea or the argument, that argument becomes void or invalid, just because you didn't plea in your petition. So I remember when I was arguing in my very early stages of litigation, I was arguing before this High Court. So one of the plea was missed by me in a writ petition, and the court very rightly objected me that you have not put in your writ petition a certain facts of which you are arguing. So on that day I learned that this is the basic principle and you cannot overlook it, you cannot miss it, in whatever condition. So you cannot miss a point and then argue that in the court. This is not allowed. You have to remember this. Whatever you are arguing, it has to be already in your plaint or writ petition. And it's very good strategy for opposing a writ petition or plaint in a court also. And this you will learn as you read more and more files and more principles of pleadings. And if you go through this case law particularly, and you will understand the basic principle of this pleading also. So the Supreme Court has observed in a case that decision of the case should be within the circumference of the pleading. The court cannot grant the relief not asked for. So it is writing the same thing. And in order to get a relief not pleaded, there has to be amendment in the pleading. So now there is a provision of amendment in the pleading, so that whatever you left out in the original plaint or repetition, you can amend that in the later stage. Maybe this is a human error. You can leave out certain things. So to amend, to improve that, okay, to improve that, you need to move a separate application of amendment, so that the pleading can be corrected and you can argue your missed out point. Move to the next page. So so these are basic things, like pleading has to be noted separately, precedent has to be noted separately. A precedent, what do you mean by precedent? Precedent is basically the rulings or the court decision that has been already passed. Okay, so now you use those rulings and the court decisions in later stages in the court. These are called precedents. Go through this word, search it for yourself, and you will know better that what precedent actually mean. You have to go through each and every part properly. So I'm just going briefly about it. Okay, so the state of Orissa versus Sudhanshu Shekhar Mishra, AIR 1968, SC 647. Note down the case law within citation. A case is only an authority for what it actually decides. So whenever you are reading a judgment, so the judgment which is already passed, and you are applying that judgment in your later proceedings or in the case, and in your matter, whatever you are pleading in the court, so it has to be taken in account of what actually it decides. Like a a, a judgment has some boundaries. Okay, so it has separate facts, separate cause of action, a separate decision, okay, or a separate reasoning to it. Whenever you are using that precedent or the case law, it has to be it has to be applied exactly, like it's common saying that is squarely covered by certain case law. So what do you mean by squarely covered is that I am covered by this case law in all circumference. A certain part of the case law, like cause of action or the facts or the legal reasoning or the observation part or the finally the decision part, you cannot pick and choose. Okay, you cannot pick a part of a judgment and use it for your use it for your benefit in your case law. In your cases, that is not allowed. You have to properly see that it is entirely covered what you want. So that's why this is a very lengthy exercise, very vigilant exercise to exactly mark it out and research part, that you have to research for particular topic. And that's why it's very important. And that's a major part of the internship program also. Like when you go to a certain advocate for internship, they ask you to find out a case law of this point, of a particular point. So you have to see actually it's covered, the case law is covered by this point is covered by this case law or not. It has to be observed very vigilantly. And when you do not, your senior would be very much furious with you. Can be, depending what the senior you get. Kindly move to the next part. So the judgment reading part. The Union of India versus Amrit Lal Manchanda 2024 3 SCC 75. Judgments are not to be read at statutes. So the in our early stages of the litigation, or in when you are in college, so we are very briefly concerned about these judgments. So we are not particularly familiar with this also. So at that time, we certainly feel that a judgment is passed as in precedent is already there, so it amounts to a law. Like a certain judgment has been passed, and the decision part is very much relevant to a topic, so we think that it is a law now. No, it's not a law. And that's for is a landmark judgment in Union of India versus Amrit Lal Manchanda. It is clearly stated by the Supreme Court that judgments are not to be read at statutes. What is statutes? Statutes are rulings and a law, are law made by the parliament. Okay, so judgments are not in line with the statutes, cannot be read as statutes. A judgment highlighted that the ratio decidendi of a case is not to be understood from a stray word, phrase, or in isolation, and that judgment should be read contextually, not at its statutes. Kindly go through this case law. You will understand what I'm trying to tell you. Okay, kindly move to the next. So this is the CPC workflow. It is in the civil side of the litigation, and in very basic understanding. When you are doing a civil work in civil court, so these is the workflow you go through. Like you file a plaint, the summons are issued by the court, the WS has to be filed by the opposite party, the issues are decided by the court. The court calls upon the evidence of both the parties. Then the arguments are done by the parties, both the parties concerned. And finally, the judgment part, the judgment is delivered of the particular cause of action. What I have stated in few seconds, this procedure, this workflow takes ages in the court. Okay, so this is the particular workflow, and this takes much more time in the court, and you will feel like I filed up my plaint today, then tomorrow it will be summons, and then the next week it will be WS, and then the issues, and it will be all over in 6 months or in 2 months. No, it generally takes lot of time in this workflow. I remember one of the cases that is criminal trial. I'm still at, when I will show you CRPC workflow. Then I will please move to the next part, CRPC one. So the CRPC workflow criminal FIR and first the FIR is lodged, and the charge sheet is then the charge sheet is made by the IO concerned by the police station. Then the cognizance has to be taken by the judge of the court. Then the charges are framed by the judges, and then the evidence has been brought upon by the complainant party. Then the arguments are started, and finally there is a judgment. So one of the matter that is going in the Patiala House Court in Delhi, I am still at the charges stage after 5 years. I'm still at the charges stage. It's very disappointing and hilarious the same way, same time, but can't ponder upon it much. Please move to the next page. So this is the High Court workflow, and I have not mentioned Supreme Court workflow because the High Court workflow goes concurrently with the Supreme Court workflow also. So the same is applied for the Supreme Court also. There is a filing, there's the admission of your writ petitions or whatever application you move to the High Court or Supreme Court. Then the notices are issued by the courts itself to the respondent party, to the opposite party. Then there's a counter by the opposite party. The counter has to be filed, or the counter, you can understand, it's a reply by the opposite parties or the respondents. The next is rejoinder. Rejoinder is the additional reply to the counter of the opposite party by the original petitioner. Okay. Then after the rejoinder, counter and rejoinder are completed, then the final argument, the final hearing is to be taken place at the High Court and Supreme Court. So kindly note it down. It's a very simple workflow, but it's very important and has to be understood when you take a file for reading, and you will understand that these stages are very important. And you asked your particular lawyer whom you are going for internship, or you are joining as a junior lawyer later on in the stages, you will understand that filing takes a lot of time and patience, and this is a very important stage also. And it involves also in documentation, and then the admission stage is also very important. You have to admit your writ petitions. Many of the writ petitions get dismissed at this particular stage of admission. Then the notices are issued in certain matters, and then the counter rejoinder are asked, and the final hearing. Many of the petitions are not coming in the stage of counter and rejoinder also. Many of the writ petitions are pending in notice stage also after many years. So this is some of the disappointing part of the workflow, but don't get bothered by that scenario. You just have to be particular about this workflow only. Okay. So we move to the next page. How to read efficiently. You go with the facts of the case. The file you are reading, go with the facts. Then you go with the issues involved in the matter, in the case. Then you look for a law involving that particular case. What are the laws that is involved in the matter? Then you have to see the application of that law. Okay, the applications and the final relief, what relief it has asked. So these you have to understand and read in a file to read effectively. And in my understanding, I think you should go first with the law involved. But as it is written, you may go like this also, but I personally go with the law first, then I understand the other basic elements also. It depends upon you, and your understanding differs from person to person. So internship practical skills, file reading, drafting, codes observation and research, these These are the very basic things that your senior will be asking from you or demanding from you. So how to read file, I have already told you, and how to better draft also a bit you have understood through this session. The court observation and the research part, and the drafting also, which is not very not been very detailed, discussed in very detail. So what we are going to do, I have already talked with Shobhita Srivastava on this. He's my very good friend. So we will be arranging a separate session for these things like drafting, court observation, and research. So you can better understand every aspect of your initial trainings, so that you may decide. So what is important of what the importance of this session is to make you understand your skills and make it more evidently clear for you, so that you can identify a role that you going to do in your future and you going to take up as an job or professional objectives. So this is very basic things, how to impress seniors, um, give summaries, be punctual, take initiative, be precise. I think be punctual is the best thing that you can give to a senior. You will be punctual, he will be impressed for sure. Consistency plus curiosity is equals to good lawyer. So I have covered major topic today. So in future sessions, I will be sharing more and giving you an insight how you can uh, take up, if you want to do litigation in your future and for your future endeavors. You, if you want to take up that as a job, professional career, you may take up. And I want to you to encourage also everybody to go and do an internship with an practicing advocate at least 1 or 2 times, because in the initial phases you don't tend to understand the charisma of litigation. And with the each passing years, and after completing your law, either is 3 years or 5 years, so after doing that you tend to look up for more glamorous jobs in corporate or in LPO or whatever corporate sector you think that is good for you. But in my opinion, that's my personal opinion, and I will not force that opinion on anybody. Just want to say this that uh, look for litigation also as an option for your career, because it's very good and very social for everybody. If you like that aspect of a career, that you will be social and you are doing some good work for the society, likewise. So good luck to everybody.
Thank you so much, sir, for that incredibly insightful session. We are grateful for your time and for sharing your expertise with us. So, there are a few questions in the chat box that I can read out so that you will.
Okay,
Yeah.
please go ahead.
So, the first question is, while reading a case file, how do experienced lawyers identify potential legal arguments or weaknesses in the opposing party's position?
So when you are reading a case file, in turn go through these elements that I discussed earlier in the slides. So relevant facts and background information. Sorry. So the potential legal arguments or weaknesses in opposing parties' position. First, you have to read their reply to understand what is their contention. Okay. So experienced lawyer like me and others also, they tend to find conflicting positions of the opposite party, where they are conflicting in nature. Okay, so their position seems to shift here and there. Those facts you have to catch, and to catch those facts, I'm again saying, read thoroughly each and every word they are putting in their reply on paper. So you, by that, by reading more and more, you will understand is what is differentiating between your claim and their reply. Okay.
Uh, I'm sorry to interrupt this, but this is
Yes.
Shobita. However,
Yes.
I would just like to ask and inform others also that today Aman coming to this forum was actually an example of digital abduction, if it is
Hmm.
anything, if it is so, because he's actually traveling and he's in mid of few things. But I
Yeah.
still requested him that please do come. And as he said
Hmm.
that we are good friends, and today's his lecture also reminded me of my days of litigation.
Yes. Yes.
Yeah. So I just wanted to say, if Aman, if you're comfortable and if you have time, then only answer the questions, because as again
Yeah.
Aman again said that we may come up with a whole series of practicing at bar and
Yes.
making best of internships. So yeah, Manjari, I mean Manjari, if you could ask him if he's comfortable in answering questions and being in the meeting for another 10 to 15 minutes.
Yeah. Yeah, I can just answer these questions what is already posed upon me. So
ठीक है.
after answering this, man, I
ठीक है.
may
Thank you, thank you.
take
हाँ,
leave.
बिल्कुल बिल्कुल. Thank
Yeah.
you so much for coming, Aman.
Yeah.
And we
Thank
have
you.
Shubham sir over here who will officially give vote of thanks. So please stay for that. He's another
Okay.
wonderful person in AFIAI and a very accomplished academic. All of us were
Okay.
very excited to have you today.
Looking forward to it. Yeah.
So
So
the
the second question, please.
next question is,
Hmm.
while reading the case files, how can interns train themselves to distinguish between legally relevant facts and background information that may not affect the outcome?
Uh, to really answer this question, I think when you are reading the the facts of the cases, okay, so the facts of cases and the background information that may not affect the outcome. So facts of the case and the background of the matter really does not always poses an outcome, because what necessary for the outcome and the judgment is that you tend to know every aspect of the case from the start to the possible end or the possible outcomes. So you go to the facts, okay, and the law surrounding to it, the law applicable to it, the relief sought by the petitioner, is it viable or not, it may be given by the court or not by the court, either way. So again, now the coming part of the respondent or the opposite party, they are also replying to your contentions, okay. So they are also replying, they are also giving evidence, and the counter evidence is also on the record. So now you have to read every aspect of both the parties. You can possibly think of an outcome reading both the parties, but we tend to decide in our favor in whatever file we are reading for. Like I'm reading for a petitioner side, I will think of my possible outcome in favor of the petitioner. If I'm reading for the opposite party, like accused, so he's giving me certain fees, as a legal practitioner, I will think of favoring myself. Okay. So we do not think of either way. We have to go with the possible outcome naturally, which can be obtained by the court, reading both the sides, like on the weighing scale. So particular, you have to not I don't think you can train yourself, but you when you read more and more, you will understand with the time and experience.
Yes, sir. Next question, sir. From a practical
Hmm.
perspective, what are the key mistakes that junior advocates tend to make during the evidence stage, particularly in examination and cross examination, and what steps can be taken to avoid them?
So I think when a practicing advocate start his journey, uh, so in those initial stage, when he is junior advocate under some senior or is independent, in very rare cases, so in that time, they generally make many mistakes in their pleading. They do not think of all the legal principles they have to include and they have to abide by. So whatever I discussed in the slides are very basic and very important elements that has to be uh, taken care of, has to be in the back of mind while pleading and drafting. So there is a subject also in a law, pleading and drafting, I guess, that you have to go to very carefully read about that, because when you are very proficient in that particular field, I don't think you will make many mistakes. There are professional mistakes you tend to make when you are a junior lawyer. I think you should make mistakes very freely, because when you make mistake, you learn a lot.
So, next question. When representing one party in a cross case, what factors in the case file are most crucial to examine to build a strong legal strategy and identify weaknesses in the opposing party's version?
When representing one party in a cross case, what factors in a case file are most crucial to examine to build a strong legal strategy and define weakness in opposing party version? Okay, so when you are representing a certain party and there are certain facts that that has to be put forward in a plaint, that has to become a part of the plaint or the complaint case when you are dealing in the criminal or either in civil suit. So you have to manage and keep in mind every aspect of fact you are putting forward in a plaint. So a certain fact, whatever it may be, small or it may be of impactful nature or non-impactful nature, or a particular section of a case, or sorry, particular section of a statute or law, you have to uh, go into you have to be binding upon that particular statute, and the facts has to be well within your ambit and grievances, and you should not unnecessarily put everything, each and everything that are not necessary. Okay, so move only and mark only those facts which are necessary for your grievances, your complaint, and whatever is not necessary and whatever you think that you cannot carry in the court, do not use those facts. Okay.
Manjari, you are on mute. Like, please, if you can unmute yourself. Yeah.
Thank you so much, sir, for diligently answering all the queries. As we approach the conclusion of this session, it is my pleasure to invite Mr. Shubham Shukla, convener of AFIAI Intensive Certificate Program, to present the vote of thanks.
Thank you so much, Manjari, and it's my immense pleasure to basically extend formal vote of thanks to Advocate Mr. Aman Osmani on behalf of Asian Forum for International Academic Interaction, sir. It's really our pleasure to basically witness how practically this, starting from the pleading part, right? Theoretical part, obviously, you have briefly covered, and talking about the practical intricacies that are very important for being a law student to actually explore and go through those files, and obviously step-by-step procedure that is required. And obviously it's a very vast topic. Definitely 1 hour is not enough to basically cover even one step of it. And but I'm pretty sure that this overview of the process, be it in civil and criminal, definitely gonna help our students to understand these things better. And obviously it will give them a stepping stone to start basically reading those cases in a manner where it is definitely gonna decode the mystery behind it, and actually utilize those case laws or those files. And basically when they come and practice in court, these all skills gonna help and improve them in litigation. And underline of this whole session is to motivate more and more students to begin litigation. And definitely it's gonna be very helpful for the whole regime of Indian legal forum. So on behalf of AFIAI, I would like to express sincere gratitude to Mr. Aman Usmani sir, and I would also like to thank all the participants for being so patient listener and obviously being very inquisitive about asking all these wonderful doubts, and sir to you for addressing them quite briefly and yet elaboratively. I would also like to express sincere gratitude to the organizing committee member Professor Shobita and Professor Kunal for obviously coming up with these new ideas where we get more opportunity to learn together, and bringing in all these experts where definitely the overall journey becomes more overall good learning experience for each and everyone. And I would like to also point out the fact that tomorrow again we'll have the same session at the time, I think around 7 p.m. So would love to have all the participants join there. Thank you so much, sir. Thank you.
Thank you so much, everyone, for being such a wonderful audience. Wishing you all a great learning experience ahead. Thank you.
Thank you, Aman. Thank you for coming again. And with this, I think we shall end the meeting. Thank you, everyone, for being here. Tomorrow, we have the session at 8 p.m., where we will discuss preparation for American bar examination. Thank you. Thank you, Shubham, sir.
Thank you. Thank you, sir.